Hello, my name's Sherry. I'm the Chief Operating Officer of ICVA, and I'm here today to take you through our bite-sized training for schemes and independent custody visitors on children and young people in custody, the diversion and release. So the objectives of this session then are to consider the legal requirements and guidance for detaining children and young people, to consider points at which children and young people could be diverted from custody, and to examine release arrangements for children and young people. So I hope you enjoy the session. To start with, we'll have a little bit of a look at context and look at how many children are coming into custody and trends with that. So without further ado then, this rather busy slide, and I can give you a copy of this on request if you'd like, but you can also find it on the gov.uk website if you'd like to. This gives the arrest figures for children over since 2006 through to 2019-20. So although it's arrest figures, obviously that will be reflected in the figures of young people that you see in custody. And you can see that there's a large decrease and a decline in child arrests. The decline is much greater for those aged 17 and under than it is for those 18 to 20, but there were previously many more arrests of children between 10 and 17. So overall, you can establish that custody numbers of children will have declined in the past sort of 10 to 14 years. Interestingly, the numbers of under 10 have dwindled to just 6 in 2019 and 20. And again, those are the children that have been arrested who are under 10. So, for example, those children are children who may be under the legal age limit. So they were arrested believing that they were 10 or over and therefore met the age of criminal responsibility in England. But in actual fact, transpired to be under 10 years old. So there's been a great deal of focus on reducing the numbers of children coming into custody over the past few years, and still yet more on overnight stays and children being kept in custody overnight. And ICVA has an entire bite-sized training on the Children's Concordat, including a video resource. And please do ask your scheme manager if you are interested in undertaking those bits of training. But the NPCC, which is the National Police Chiefs Council, had a strategy for children and young people in 2015 to 17. And that states that they recognise that there will be occasions where young people are rightly detained in custody and that the use of the youth justice system is necessary to address their offending behaviour. However, they also recognise that for the majority, entering custody for the first time is a traumatic experience. And again, to link to one of our other resources, Dr. Miranda Bevan undertook some lengthy research into children in police custody, and you can see her Bitesize, which is a series of videos which have quotes from children who've been kept in custody to kind of help you work through what that might feel like for a child or a young person. So back to the NPCC. So they say that we need to make sure that young people enter custody for the right reasons at the right time and that we appropriately explore other options first. And we'll go on to discuss some of those other options. We will work with partners to improve our custody facilities for young people, but more importantly, we will seek alternative disposals and ways of addressing behaviour. So again, in terms of custody facilities, we have an ICVA Bitesize on treatment and conditions in custody for children and young people, which is very similar format to this in that I present some slides for you for your consideration and to adopt into your work and monitoring. And the final point, it's important that young people are not criminalised for behaviour which can be dealt with more appropriately by other means. We need to work in partnership with the Youth Offending Service and criminal justice agencies to ensure the right support and intervention is in place to reduce offending. So you can see then that as far back as 2015, which Feels, quite a long way away now, but nonetheless, as far back as then, there was a real drive for and a strategy to assist with the numbers of children and young people entering custody. So numbers have reduced, strategies have been in place. So what then happens and to children and young people who are arrested? What does diversion mean, and what rules are there around detention? So firstly then, let's have a little look at the point of arrest. So there are some opportunities to divert from custody at that point of arrest. And there are two most common diversionary routes, and one which is slightly less common that we'll talk about as well. So being released under investigation then, and I'm sure most of you have heard of RUI. So this means that the child or young person has not been charged and that the police need to do further work to obtain evidence prior to referring to the CPS for a charging decision. So it can happen at the point of arrest, or it could happen, someone could be released under RUI from custody. There's no limit to the time someone can be released under investigation, and there are no conditions attached to it in the way there might be with bail. So you'll all be very familiar with bail. But that can happen at the point of arrest or in custody. Once some of the sort of initial custody process have taken place, it might be that the police need to get some further work post or prior to interview, and therefore a child or young person could be RUI'd. You will also have heard, I'm sure, of voluntary interviews, also known as voluntary attendance. So that's a voluntary police interview taking place at a police station, or sometimes elsewhere, but more often than not a police station, where the volunteer assists the police with their inquiries. So the child or young person isn't under arrest at that time, but the interview will be recorded and will take place under caution, meaning it can be used as evidence. So anyone who goes in under a voluntary interview needs to be really clear on those specific points, that actually it will be under caution, it can be used as evidence. The third opportunity to divert is something called street bail, and those of you who've been in criminal justice, like myself, for a little bit longer might have heard of street bail, and certainly it used to be an awful lot more common. And that enables a person arrested for an offence or taken into the custody of a police officer after an offence to be released on bail by a police constable on the condition that they attend the police station at a certain date and time, at which point they're expected to be taken into custody under caution and interviewed, and then either obviously charged or released in the normal way. Anecdotally, though, street bail is used much less often than RUI or voluntary interview these days. Street bail used to be a lot more prevalent, but it's worth you knowing its existence because it can still be used. So these are just some of the ways then in which at the point of arrest or in custody a child or young person could be diverted from the custody suite. So then, assuming that one of those disposals hasn't been used at the point of arrest and our child or young person is taken to custody, they will need to be brought to custody and presented to the sergeant. And that means that then the sergeant or equivalent needs to authorise detention. And so the authorised professional practice from the College of Policing states that detention is always the last resort, and custody officers should authorise detention only when it's necessary to detain, rather than when it is convenient or expedient. This decision should not be seen as rubber stamping of the necessity to arrest, but as a separate, independent decision. The determination of necessity continues throughout the time in custody and should be regularly reviewed as per PACE section 34.2. So essentially, a custody sergeant could potentially refuse to authorise detention. So the arresting officers present the child or young person and say, we've arrested such and such for such and such a reason. And the custody sergeant at that point could say, well, actually, I think I don't think there's a necessity to detain here. I think you could deal with this child or young person perhaps via one of the other routes that we've just discussed, such as RUI or arranging for them to return for a voluntary interview. And they might particularly do that if it was late at night. The reason for arrest is not a particularly serious one. There's a whole host of reasons that might impact on the decision. So a few to note really are the nature of the reason for arrest, the compliance of the child or young person with their arrest, whether they're giving their name, date of birth and address in a kind of compliant way, so that actually one of those other disposals might be better for them and they're complying well with the process. So all of those things will go into making the decision about whether someone will be detained or not. And if they are detained, then onwards goes the process, which you know well. But this is another point at which children or young people could be diverted from custody. So they could be diverted at arrest, they could be diverted when they come into custody itself and not detained. So once we get into the suite then, I always find these things a little confusing because there's liaison and diversion, and then there's diversion schemes. And so I thought it might be nice if we just spend a little time looking at whether they're the same thing, what they mean. So are diversion schemes the same as L&D? And the answer is no. No, they're not. They're different interventions. And we'll just pop through a couple of features of both. So diversion schemes are things like Divert, which you may have heard of, and they offer a casework support service. So they're an independent service that come into the custody suite and talk to children and young people. St Giles Trust have one. There's many of these diversion schemes across the country, and they offer the child a casework support service. So liaison and diversion then is a screening and onward referral service. So L&D will look, and we'll look at what each of those are in more detail in the next slides. But children and young people might come into contact with both of these services, so they're not mutually exclusive, but they are different. They do offer different things. So what is liaison and diversion then? Well, an L&D service identifies people with mental health, learning disabilities, substance misuse or other vulnerabilities coming into contact with the criminal justice system. They assess and refer the identified individual to an appropriate treatment or support service. And they share, with consent, information gained from assessments with criminal justice agencies and the judiciary, so they can make more informed decisions and timely decisions about out-of-court disposals, case management and sentencing. Many custody suites have liaison and diversion. I think probably most now. And as an ICV or a scheme manager, you might want to check if you don't know who your local service is, and what their referral criteria are. So for some areas, I know that children are automatically referred to liaison and diversion for screening due to their vulnerability by age, so they get an automatic referral. But in other areas, that may not be so. So it'd be great if you find out what your referral criteria are for L&D in your suites. So what are diversion schemes then? Well, they often get referrals in custody, so they assist with diverting from offending behaviour and future arrests. They tend to be localised rather than national schemes, whereas L&D is a national scheme. Diversion schemes are often delivered in custody by third sector organisations, so I mentioned a few earlier on, and do check their websites if you'd like to see if there's anything in your area. And they provide casework or coaching services to children and young people in custody, and can assist with a range of things, so mentoring, employment, training, housing. So a diversion scheme will tend to have a more wraparound support package for a child or a young person. So a child or young person engaging with a diversion scheme in custody doesn't mean that they won't be charged, and it doesn't mean that they won't attend court if found and possibly be found guilty and sentenced. What it does mean is that during this process, the child or young person will have some support. It means that during this process, which can sometimes take a while depending on the nature of the charge and the delays in courts, it means that they could potentially engage in employment in that time, in training. They could attain more stable housing, assistance with any drug or alcohol needs or mental health, and receive mentoring. And their engagement with the scheme and also with those other aspects may have an impact at the point of sentencing, should they be charged, found guilty, and then require sentencing. So there are some other possible diversion considerations then. So in some cases, it may be that a child or young person has a youth YOS worker or youth offending service worker, and they may be their appropriate adult during their time in custody. And the YOS might have access to other diversion services for children and young people, which they can be referred to after they're released from custody. And of course, the Youth Offending Services contact with children and young people is national. So where some of those other schemes might be in existence in some areas but not in others, the Youth Offending Service covers all children and young people in England and Wales. A young person may accept guilt and accept a caution at this point, and so that could be considered as a diversion. So they may not need to be charged and attend court. Although I would give a note on cautions. So there are different types. So there are a youth caution, which is a verbal warning given by a police officer to a young person who admits they're guilty of an offence, depending on the seriousness of that offence. So you wouldn't get a caution for some of the more serious offences, for example. A youth conditional caution is for a more serious offence. It's a caution, but with conditions attached to it that the young person must do. So children or young people accepting either type of caution would be automatically referred to their youth offending services. There are other types of cautions, but these are the ones specific to children. Any child must admit guilt and accept a caution in order for one to go ahead. If they do not accept it, then they might be arrested, or if they're already in custody, they might be charged. Children and young people in custody must be made aware that a caution could show up on any future criminal record checks. And although they're spent immediately, they could appear later in life. A child or a young person has the right to have a caution fully explained to them and has the right to speak to a legal representative. And we know, and those of you who've watched Dr. Miranda's Bevan's videos, we know that often children are very, very keen to get out of custody at the first possible point they can. So therefore, the kind of impact of a caution is really important for children and young people to know. So you might want to check the custody record or something along those lines, or for just your information really, is to know that children have been fully explained to, or their appropriate adult is aware that cautions could appear later in life. So those are some of the things that can happen in custody then. So there's diversion schemes, there's liaison and diversion, and a range of cautions that could divert children and young people from custody. So we've now looked at what can happen at the point of arrest. We've looked at what can happen whilst children and young people are in custody. And we will move on now to have a little look at release and specific release arrangements for children and young people. So the inspectorate then, it's a joint inspectorate from HMIC FRS and HMIP, which is the inspectorates for both the police and fire service and the inspectorates for prisons. They form a joint inspectorate to inspect police custody. And they have a list of expectations which they inspect against in order to produce their reports, which are on public websites. So if you're interested in your inspectorate report for your police area, please do have a look at the Joint Inspectorate's website and you'll be able to find the last report. Inspections happen about every 6 years, so they're not terribly frequent, but they are massively in-depth inspection reports for you to have a read of. The expectations then state that pre-release risk management planning for detainees is conducted to ensure that they are released safely. So there's an expectation on the police that they will ensure that they do some comprehensive risk management prior to release. And they have a series of indicators, so things that they'll look for in order to satisfy themselves that that expectation is being met. And those include that there are good quality pre-release risk assessments which are completed with the detainee. They're documented and identify any risks and vulnerability through their period of detention. Action is taken to reduce any risks and welfare concerns prior to release. Appropriate relevant information about risk, vulnerability or safeguarding is communicated to relevant agencies and support organisations. Particular attention is given to safely managing the release of vulnerable detainees. And once again, I make the point that children and young people are vulnerable because of their age. They may also have additional vulnerabilities, but they would be in the vulnerable category for that reason. That there is up-to-date information, including contact details for support organisations, and this is provided to detainees in a format and language that they can easily understand. So detainees on leaving custody should have some information, whether that's a leaflet or a range of things, about support agencies that make sense to them, that they understand, and again, that's in a language that they understand for onward support after release from custody. So what then does that mean precisely? What do those expectations really mean for children and young people? Well, they're vulnerable by deem of their age. And some considerations for custody staff might include things like whether someone's coming to pick the child up from a suite. If they have an appropriate adult still there with them at the point of release, are they going to take them home? If no one is coming to get the child, or there isn't anyone present who can take them home, can the police facilitate transport for them? The time of release might be particularly important, in particular at night. So is it safe for the child to get home at that time? Consider the environment of the suite. So whereabouts do they live? Is there transport available? Is it actually safe for a child to be released at that time? And it seems a bit of a strange one to pop on, but we do get reports of detainees being released in inappropriate clothing. So it's really important that the custody staff have a think about what clothes they're released in. So do they have shoes, and are they appropriately warm? Are they, are those clothes things that they should be out on the street in? Furthermore than that, there's a note on county lines, and we have produced a specific briefing on county lines, so please do ask your scheme manager if you'd like a copy. But county lines is a term used for drug distribution networks, and I'm sure many of you have heard it. The higher-ranking gang members who organise the sale and supply of the drugs remain in the cities and groom children and young people to go and sell the drugs outside of the cities in the county, so in smaller cities and towns. This does mean that children arrested for drugs offences or as part of a drugs operation may not be arrested in the same place as their home, and in fact they could be many, many miles away. So, for example, quite often county lines will follow train lines. So you may find a London young person arrested in somewhere as far away as Weymouth, which is sort of 3 hours on train, and things along those lines. So it could be a long distance from their home. It could be that child is then returned to their city with no drugs and no money, depending on what's been taken at the point of arrest, which then puts them at risk and the higher-ranking gang members for loss of income to the gang. So there's a real risk there around if they've been arrested and either released under investigation, but there's still been some sort of confiscation of evidence, then they have to return back to their city without those things. So specific release arrangements might be necessary in order to keep this group of children safe. So that might include things like safeguarding referrals. It might include linking in with youth offending services, discussing with social services and various other bodies. Some police areas, because of the prevalence of county lines, have specific county lines teams which ensure the safeguarding and safe return of children who are arrested as part of this particular type of offending. Do check if there's anything in your area, and often your custody staff will be aware of county lines, so you might want to, next time you're on a visit, just have a chat with the sergeants and the DOs and see what their arrangements for county lines children are. So then, just a quick recap. So we've had a look at the legal requirements and guidance for detaining children and young people. So we've looked at what can happen at the point of arrest. We've looked at the guidance on necessity to detain. And we know that children don't always have to be detained in custody. There are other options for them. Although custody will, for some offences due to the nature of the offence, or for children who are not compliant with that process and not giving details and the like, custody is still very much going to be the outcome for some. We've considered points at which children and young people can be diverted from custody, so at the point of arrest, at the point of detention, and then during their time in custody, they could be reconsidered as requiring IUI or coming back for a voluntary interview. And we've had a look at the release arrangements for children and young people and shared the inspectorate's expectations with you. And you can look at those indicators, and maybe when you're looking at custody records and things along those lines, you can really check that those features are there and that children and young people in your area are being released safely. As I say, there are many other resources we have. This is the last one for our theme of children and young people this year. Please do check with your scheme managers for other resources, and do request any briefings you would like, or email me at info@icva.org. Many thanks indeed. I hope you enjoyed the training.